Hello everyone. I hope this message finds you fit and fine. For a moment, just consider that you don't have any conception of rights in your life. Rights means something which you consider as truly yours. And society also adhere to this idea. Yes, this belongs to you. And that is why you set claim on those things from family, society, or government. Now consider you don't have this conception of right in your life. What kind of life you would be living? Do you think it would be better off or it would be worse off? Now you can actually connect that we cannot exist without various rights in our life. We need something which we can claim. These are necessary for our development, for our basic existence. Right? Now, out of these innumerable rights, certain rights were given some prime status by our constitutional framers. And this status is fundamental rights. The word fundamental itself means that these are of utmost importance. These are mentioned in Part 3 of Indian Constitution, starting from Article 12 and ending on 35. And why they talked about fundamental rights? I hope all of you would agree on this point, that we learn from our experience. In our colonial history, we have experienced the travesty, the exploitation which is done by government if there are no limitations on this government. So this conception of fundamental right, as mentioned in Indian Constitution, put limitation on power of government so that you can enjoy your life in the best possible manner without compromising others' life. And that is why our fundamental rights are not absolute in nature. It means if we talk about any fundamental right in our Part 3, you should not consider that this is available to you in every situation. No, nothing is available in every situation. Terms and conditions are applicable. Right? Before we enter into this domain of fundamental rights Part 3, you should know there are three types of questions which UPSC is asking, specifically in Indian polity. One are on principles. From principles part, generally questions are not being asked from Lakshmikant specifically. For that, you should refer NCERTs. For example, today we are starting fundamental rights. So you should not think that UPSC is going to ask you question on specific provision only. When I say provision, it means what this article in Constitution says. Means they will make a statement and they will ask, this statement is true or not. So you can answer if you have understanding of the provisions in our Constitution. But sometimes, for example, 2-3 questions are being asked on principle part, the basic conception of right. For example, we are talking about Part 3 of Indian Constitution, fundamental right. But UPSC can make a statement on this idea of legal right, natural right, civil right, political right, right? So it means you should have understanding of these ideas and how fundamental right is evolving from these ideas, right? So those are principle kind of questions. Now the process part. As you move into Indian polity, you also find in different articles and subsequent laws which are made by Parliament, there are certain processes by which this political system work. It may be election process, it may be disqualification process, right? So process are also, important area from which questions are asked. From mains perspective, specifically from fundamental right, just have a look on these statements and you will be able to judge the demand of this section. 2021. Analyze the distinguishing features of the notion of the right to equality. Distinguishing features of the notion of right to equality in the Constitution of USA and India. Now tell me, my friends, if you have understanding of right related to equality as mentioned in part 3. You have understanding of article from 14, 15, 16, 17, 18. Do you think the understanding of the provision is sufficient to answer this question? Because question directive is not explain, discuss. Question directive is analyze, analysis. And the word USA is also there, na? So it means what examiner is asking. Examiner is asking whether you are assimilating this knowledge or not. ऐसा तो नहीं है you are just cramming, right? And do you require some, do you need to read some 3-4 books on on Indian polity apart from Lakshmikant just to answer these kind of questions? My answer is no. What is required is that you are having sharp eye on the demand of this particular topic. And whenever you read an article that, oh, equality is in news, so you should collect the content keeping in mind, oh, this is going to be used in GS paper 2 because these are the common themes on which questions are asked. That's how you need to structure your knowledge. First, we are building foundation and then you need to structure your knowledge over it. Because ultimately, you have to clear the exam, right? Does the right to clean the environment entail legal regulations on burning crackers during Diwali? Discuss in the light of Article 21 of the Indian Constitution, judgments of the apex court in this regard. This question is directly being asked from what was in news. And I would say this is a direct question. Because specifically asking link between this event, article and judgments, right? Means information based question. What do you understand by the concept of freedom of speech and expression? Does it cover hate speech? Now, hate speech was also in news, right? Why do the films in India stand on slightly different plane from other forms of expression? Discuss. So, another contemporary question. And you should also keep in mind that OTT platforms were in news, right? Because CBFC, Central Board of Film Certification, does not apply as of now on OTT platforms, and that is why when you go through various TV series, Sacred Games and others, you see a lot of you can say rebuking going on, slangs are being used. So they are saying that it is, and this is under their freedom of speech and expression, because art need not to be in some bound or restrictions, otherwise art will be compromised. So there's a debate on the definition of art, because acting, script, writing, this is art component. And other, we have this morality component, right, which we have to protect. So where we should balance between these two. So UPSC is asking the application part, whether you think on these issues or not. Okay. Discuss section 66A of IT Act with reference to the alleged violation of Article 19 of the Constitution. Was in news as one cartoonist, Asim Trivedi, made a national emblem, which was disfigured. Some other images of politicians were used. At the time, this particular section was invoked. Now, Supreme Court heard this, that this particular section has been misused by government many times. And that is why this was struck down. But recently it was in news that still at ground, various police administration are using, when in charge sheet they are using this particular section despite the judgment of Supreme Court. How is it possible? So if this particular thing is in news, this particular provision is in news, so you need to connect with how it is connected to Article 19, subclause 1, subclause A, right? So I hope now you are clear with the demand, the direction which you should adopt while covering fundamental rights. Part 3, Article 12 to Article 35, I have already told to you. Now, before I jump into the provision part, I want you to understand this word natural rights, because 4 words are used specifically in context of part 3, means fundamental right. 4 type of rights are associated with fundamental rights. Natural rights, legal rights, civil rights, and political rights. These 4 rights are associated with fundamental rights, part 3 of Indian Constitution. Okay? And these words socio-economic rights, another type of rights, are associated with DPSP. Please understand this difference, because this can be a statement in an exam. Part 4, Directive Principle of State Policy, they have socio-economic rights. Okay. Now, it becomes important for us to understand these words individually. Later, we are going to understand socio-economic rights. Now, what is natural right, and from where this idea emerged? So, my friends, in 17th and 18th century, various political theorists supported this idea of natural rights. And as you can see, the word nature is there. Nature. So what was happening in European countries in 17th, 18th century? What kind of government which was popular there? All of you are aware, monarchy was the most popular form of government, right? And we know that king at that point of time was enjoying absolute power. Absolute power. Absolute power means whatever comes into the mind of the king, king will do that. And that act will be considered as legal act. And all of you, if you were considered about the people who were living at that point of time, it was responsibility of the people to accept whatever is declared as legal by this king. And so don't you think this lead to some arbitrary action? Arbitrary action, and arbitrary action leads to exploitation, right? I hope you are able to connect with this journey. Exploitation. Now, some political thinkers was thinking we have to save people from this exploitation. So that is why they arrive at this concept of natural right. They said some rights are given to people by Mother Nature. These rights are given to people by God. Some of you might be thinking, ऐसा कैसे? How can this happen? Means बोलना एक बात है, लेकिन लोग जब तक accept नहीं करेंगे, if people are not accepting this, then this idea cannot actually have some ground. This idea will not be accepted, right? So why would people accept it? So these theories said, there's a logic inside. You are given life by king or nature. You will say nature. So you are given life by nature. Don't you think by this logic you have right over your life? Because your life is not given to you by king. Life is given to you by nature or God. So how can king arbitrarily take action and take your life? This is wrong. Right? And earlier kings were saying, this is my divine right. And they said, no. Ye sab nahi chalega. This is leading to exploitation. We need to understand new truth. And new truth is life. Along with this, can you actually live without property? When I say property, what comes into your mind? Some house, right? Car, bungalow, right? No. When I say property, it means possessions. Can you live without possession? Just look around when you are sitting. You have possessions around you. You have clothes over your body. That is your possession. That's your property. For existence, we need some possessions, property. right? So if life is given to us by the God, and God or nature has made us in such a way that we need possessions to actually continue, it means nature has given us right over property, right? Now you have thinking ability. You can think. If you want to go outside, you can go outside. No one will stop you. Why? Because you are given this ability. Thought comes into your mind and you move out. Thought comes into your mind, you start writing. Thought comes into your mind, you start reading. So it means these actions are occurring in your brain. So it means liberty is a component which is also given to you by nature. And now you're able to understand life, liberty and property. These are the three kind of rights which were given primacy from this 70th and 18th century. And that is why these rights are part of fundamental rights as well. Property was also part of fundamental right in our original constitution. Later, this right to property was removed. But earlier, it was part. Right to life mentioned in Article 21. Article 21 talks about right to life and personal liberty. And this liberty as an idea is spread in many articles in Indian Constitution within fundamental rights. Be it your speech and expression, your right to move freely, right? Right to choose your profession, right to form association, all of this, what this represents? This represents liberty. Because all these three types of rights are necessary for you to live your life fully. Right? And this is emerging from this concept of natural rights. Natural rights. So if UPSC is making a statement that our fundamental right as mentioned in part 3 incorporates rights derived from conception of natural right, that statement would be true or false? You will say true. Abhi abhi आत्मज्ञान हुआ है आपको, right? Now, when everything is correct, ठीक है, natural right you accepted, then from where this concept of legal right emerged? अब इसका क्या पंगा है? Legal rights. So the word legal, it comes to this word law, right? Now some other theorists of the same time, they say we are against this concept of natural right. And when the supporters of natural rights asked, why you are against this concept of natural right? At least by this concept of natural right, we are able to put limitation on this government. Now government cannot take away our life, liberty and property without proper law which is accepted by all. So it is good for all. What's the problem you are having? Now the supporters of legal rights says, you have given too much power to the people in the name of life, liberty, property. And we have an alternative logic. Then the supporters of natural rights asked, what logic do you have? Then they said, consider we accept your concept that yes, life, liberty, property are necessary. But when you use the word right, these are connected to claim. And do you think there will be any value to any claim without these claims being settled by someone? There should be some settlement of these claims as well, na? And how you can settle? You can only settle these claims, for example, your right to life, for example, your right to property. You are having this right, you are claiming. But can you actually enjoy your right to property, your right to life, liberty without a law made by government? What would be your answer? Yes or no? Your answer would be no, sir. Government को हल्के में नहीं लेने का है. Government का role तो है. Because you are able to enjoy this life, liberty, property because they are mentioned in a law. There's Article 21 there. There are Article 19 and other fundamental rights. That's why you are able to say, yeah, we have these fundamental rights. So, Constitution is the fundamental law. It means without law, no matter how many times you jump this, you actually, you repeat this, no, this is our natural right, this is our natural right, but no one will give you this natural right until and unless it is backed by law. So that is the importance of the concept of legal right. So it means, according to legal right, who is the source of right? It is not nature. It is state. When I say state, it means government. And why? State is source, because state make law, and by this law you are able to claim this right. And now, if I ask whether we have this component or principle or say concept of legal right in our part 3, you will say yes. Because without law, how can we actually go to Supreme Court to ask that this fundamental right has been abridged, right? So this is conception of legal right. Now, the third, civil rights, quite easier one. Can you imagine your life without any order in society? You come out of your home and you move freely because you have belief that others are going to, have their conduct in orderly manner. Means there's an order in society which people have to follow. It means we need a civilized society. We need a society where there is order. And this order will be only possible when rights are clear. What you can do, what you can claim, that is clear. And where are the limitations? Till what point you can exercise this right? So it means all rights which are necessary for your civilized life. It means to bring order as well as you utilizing your potential. Because only when you have certain rights, right to actually say equality as well, that you are equal in front of law, right to say have equality in terms of opportunity, right to have equality in terms of opportunity in public employment. It means these steps are connected. And that's how you'll be able to lead a civilized life, a life where you'll be able to realize your potential, right? You don't want to get discriminated. This is possible only when this conception of civil rights are adhered to when you talk about rights. And don't you think these are mentioned in our Constitution? Fundamental rights? Yes, they are. We're going to talk about them, right? Next, fourth, political rights. So what comes to your mind when you read this word political? I think election comes to your mind, right? My friends, the word political is way elaborate, is very much, is more than just election. Your stature, your relation with respect to the laws which are in place is also having political component there. It means when we say political, the basic idea is that you have right to participate in political process. But my friends, you will be able to exercise this political right in modern time only when you are treated equally in eyes of law. And that is why this principle of political right is also imbibed in our part 3 fundamental right. I hope now you are clear about these principles, right? Now let's move ahead. In original Constitution, there were 6 types of rights which were given the status of fundamental rights. During Constituent Assembly debate, some members were saying we should have more rights to be declared as fundamental rights. At that point of time, one person, Mr. B.N. Rao, who was legal advisor to Constituent Assembly, he said, let's divide the conception of right into 2 parts, part 3 and part 4. Part 3 will be given the name fundamental rights. It means it will be responsibility of state to ensure that these rights are given to the people, fundamental. And other kind of rights, which were socio-economic rights, B.N. Rao suggested, since our capacity of our government at that point of time, which is going to be formed, as well as political reality as well as social reality. When I say political social reality, it means aspirations of the people, demand of the people, commitment of the political parties of the time to actually make laws on these topics. So B.N. Rao suggested we can leave some things as some rights as DPSP, Directive Principles of State Policy. It means in future, whenever state is going to make policy, state is going to consider these principles mentioned in part 4 as directives. Now coming back to the topic, fundamental right. So we have 6 now, because 7th, this fundamental right on property was removed from fundamental right and placed in Article 300A. So we are going to start from right to equality. First, we are going to talk about Article 12, Article 13 today. Then we are going to talk about right to equality. Then right to freedom, right against exploitation, right to freedom of religion, which is in news nowadays due to this hijab issue. Cultural and educational rights, right to constitutional remedy. Now these are some keywords which you can associate with this part 3, fundamental right. Words like Magna Carta. This Magna Carta was one royal charter which was signed by King John. I'm talking about 1215, who was signed by King John, who was unpopular king, and that's why his rule was in turmoil, and he was facing some resistance from local barons. Barons means landlords at that point of time. They were unhappy that king was actually working on his whims and fancies. He was changing taxes. He was putting these barons in imprisonment on his whims and fancies. No order, no security was there. No limitation was there. It means exploitation was happening. As they voiced their concern, and church worked as mediator at that point of time, so they actually made a document on which certain rules were clearly mentioned, that these will be limitations around which government will adhere, and these are the responsibilities of barons. So barons got assurity that yes, now this government is going to ensure these rights as our basic rights. And from there, this word Magna Carta became popular. Although the Magna Carta which was signed at that point of time was not, you can say, successful. It got changed later. But this idea gave us hope. Oh, there can be some rights which can work as a contract between state and common people. Right? Now it is not just about barons, it is about all the people. Uphold larger public interest. This is the purpose of fundamental right. Not sacrosanct or permanent. It means they can be changed. Yes. And we are going to talk about this debate, to what extent they can be changed. You cannot change or you cannot amend these fundamental rights to an extent which abridge basic structure of Indian Constitution. It means to some extent they are safe, right? But Parliament is given the power to amend fundamental rights. We are going to talk about case-to-case journey also. Justiciable, it means if they are abridged, you can directly knock the door of Supreme Court using Article 32. High Court, you can go for your fundamental rights using Article 226. Guarantor, Supreme Court is the guarantor. Because in Part 3, Article 32 specifically talks about Supreme Court and how Supreme Court can use these writs to safeguard your fundamental rights. Available against state and private individual. Please remember that. Many students remain confused in this part. When I say putting limitation on state, that it was the objective of having these rights. But there are certain rights which put limitation on individual, private individual as well. For example, Article 15 says that there shall not be any discrimination on the basis of religion, race, caste, sex, place of birth, but it is applicable on individual as well as state. You as an individual cannot restrict entry to a public park of a person just because he belongs to a different religion. That would be against Article 15, fundamental right. So it means this is applicable on you as well, not just government, right? Similarly, Article 17 related to untouchability. Now, negative in nature. Please remember, negative is not about bad. Negative means that these fundamental rights are putting some restrictions on state, and then only you will be able to enjoy your rights. Look at the language. Article 15 state, for example, there shall not be discrimination. Shall not be discrimination. Discrimination नहीं करना है. Article 16, a state shall not discriminate. Discrimination नहीं करना है. So it means when restrictions are put on state, then you are able to enjoy these rights, and that is why it is called negative rights, negative conception of right. Okay. Now I'm making a statement. I have not started, but I'm making a statement to actually tell you what kind of questions can be asked. With respect to the status of fundamental rights, it only incorporates negative conception of right. It only incorporates negative rights. This statement would be true or false. This statement is saying कि सभी फंडामेंटल राइट्स में केवल यही कंसेप्ट लगा हुआ है दैट स्टेट को ये नहीं करना है, स्टेट विल नॉट डू दिस. या कुछ ऐसे फंडामेंटल राइट भी हैं, डू यू हैव दोज फंडामेंटल राइट्स वेयर स्टेट इज बाउंड टू डू समथिंग in order to make you enjoy your rights. Take a look, Article 21A, right to education. Right to education is not just talking about what state should not do. It is talking about what state has to do. That is positive conception. And I remember one statement which was made by Justice Chandrachud, Supreme Court judge. So he said that even Article 21, when you talk about right to health, it is an interpretation from Article 21. We are going to talk about it. It should not be considered just as negative conception. It is having positive conception. And this positive conception of fundamental right was also exercised by Supreme Court during this second COVID wave when oxygen shortage was there. So when the discussion, deliberation was going on at that point of time, this debate also come up that yes, positive conception of fundamental right is what we need to accept apart from negative conception. Right? I hope you are clear. Negative means state should not do this, then you will be able to enjoy. Positive conception of right means state has to do this, then you will be able to enjoy your rights. Okay? But moreover, fundamental rights are tilted towards negative conception of right. Okay? Guaranteed to everyone except Article 15, 16, 19, 29, 30 because they are only available to citizens. Now, let's talk about Article 12. First article of it, you can say fundamental rights. It talks about the word state. Definition of state. So, why we are talking about state? As I told you, fundamental rights are putting some limitation on state, right? Now, who should be the state? On which entity these fundamental rights are applicable, where you can knock the door and say, oh, this entity, this government body has actually taken away my right. So that is why it was important to explain what is the meaning of state. So Article 12 explains Union Government and Parliament of India. It means executive and legislature at the level of union comes under the definition of state. Clear? Similarly, executive, legislature at the level of state. When I say state here, it means provinces, Uttar Pradesh, Madhya Pradesh, Maharashtra, Andhra, right? So they will also come under the definition of state. Means whatever conditionalities, responsibilities are given to state in fundamental right, they should be applicable on them. These entities should consider, oh, these are applicable on me. All local bodies, all authorities, it means Panchayati Raj, municipalities, municipal corporation, these all come under the definition of state. That is quite clear, right? Local, state and union. Now, you should take a look over this fourth point. Other authorities within territory of India or under control of Government of India. Now, what other authorities can come under the definition of state? Now, I'm making a statement. You have to tell me the statement is true or false. If I say, no private entity can be considered under the definition of state as mentioned under Article 12 of Indian Constitution, do you think that statement would be true or false? Take a look over the Supreme Court. What Supreme Court says. Even private body or an agency working as an instrument of state falls within the meaning of state under Article 12. So it means private body, if it is working as an instrument of state, engage in certain responsibilities which we connect as a responsibility of state, then that private agency, private body can also be considered as state under Article 12. Please remember it. It is important. Okay. Now talking about Article 13. Article 13 is a kind of protection shield to the fundamental rights which are given to us. Why protection shield? Laws inconsistent with fundamental rights. Those laws which abridge fundamental rights which are given to us. What is going to happen with these laws? As I said, protection shield. Fundamental rights become operative from 26 January 1950. So now, this Article 13 says that your fundamental rights are primary. These laws cannot take away your fundamental rights. So when I say laws, so we need to categorize these laws first into two parts. Because some laws were present in pre-constitutional era also. It means our constitution was enacted, commenced on 26 January 1950, and there were many laws which were made by Britishers which were already in operation in Indian territory. And we did not repeal everything. Many British time laws are still working in India, right? But Article 13 says, if any law which is pre-constitutional, but this law is abridging fundamental rights as mentioned in Part 3, then what is going to happen? That particular law will be declared null and void. Now, in what way they will be declared null and void? In violation with fundamental rights, now they will be declared void. Now, there are two ways to actually make this particular provision of this law void. There are two ways, two concepts. One is doctrine of severability. This word severability comes from the word sever. Sever means cut karna. You are actually cutting a piece of a law because you are thinking this is of no use. So now you can connect what doctrine of severability says to separate, right? It means if this is a law and this law is having say 5 points, okay, 5 points are there, and we see that 2 points are actually abridging some fundamental right, right? So now what doctrine of severability says? Now we are going to cut these two parts away, these two provisions away. Now this remaining law will be in place, but these two parts will be, these two provisions will be cut it out, right? Now, this doctrine was used by Supreme Court in A.K. Gopalan case. A.K. Gopalan, a communist leader who was lodged in Madras jail, and he filed a petition in Supreme Court that my fundamental right is being abridged. Supreme Court said, which fundamental right? He said Article 14, Article 19, Article 21, Article 22. Supreme Court said, oh, it seems like it's a serious case. Let us know how these are being abridged. So A.K. Gopalan said, I'm a communist leader and I'm put in preventive detention by the government. Preventive detention means I have not committed any crime, but because this government think I'm a threat, that is why they have put me in preventive detention. Now Supreme Court said, what is the problem in that? If you're a threat and there's a preventive detention law 1950 in place, and the same year this particular case was being heard in Supreme Court. So what is the problem? That law is clearly saying that government has this power to put you in preventive detention. Then A.K. Gopalan's advocate said, sir, the point is that there is section 14 in this preventive detention law, and it says that the ground on which this concerned person, means A.K. Gopalan, has put into detention, this ground cannot be furnished even before court of law. Just Saab, this law is saying that the basis on which this A.K. Gopalan has put in preventive detention, we cannot actually put these reasons even before court of law. Court said, what is happening? Means, how can this law say that? This is clear-cut indication of undermining of judiciary. So at that point of time, Supreme Court used Doctrine of Civility. Why? Because Article 13 talks about that if law is inconsistent, then that particular law will be void, right? Now, who is going to do that? Obviously, judiciary. But this particular section was undermining judiciary. This concept of judicial review is emerged from this very article, Article 13. And to protect that, judiciary used this doctrine. I hope now it is clear. Means section 14 was declared that it would be null and void, it would be inactive, and other part of that law will continue. Now, doctrine of eclipse. You know eclipse? So eclipse is permanent or temporary. Solar eclipse, lunar eclipse. I hope you have read about or you heard about eclipse. Bachpan mein you have seen also. So it is temporary in nature, right? So doctrine of eclipse says that the provisions which are actually, you can say, abridging fundamental rights, we are going to keep these provisions into sleep. Means sleeping section. And this was said in Bikaji versus State of Madhya Pradesh in 1955. It means we are not cutting the provisions and declaring them out. We are saying this will be a sleeping section. Fundamental rights will overshadow inconsistent laws till and any amendment comes in fundamental right. It means they will be there, but they will be in eclipse. Because who is superior? Fundamental rights are superior. And at any point of time, if there is amendment in fundamental right, then that particular sleeping provision will wake up, right? And in this case, you have already cut it out. If you want to bring that provision back, then you have to repeat the process. You have to bring that law in bill in legislature, then you have to pass, and then you can actually bring that particular cutout part again in the law. But here it is in sleep, right? That's how our legal framework works. Now, Article 13, Subclause 2, it talks about post-constitutional laws. It means laws which are made after commencement of Indian Constitution. It says that since you have already read Article 13, so you should be clear that you should not make any law which is inconsistent with our fundamental rights. A state must not make laws that are not in consonance with the Constitution fundamental right. If such is the case, then they will be declared null and void. Whether the law that is declared void is non-existence with respect to non-citizens of India, if this statement is used in any manner. So what does it imply? It simply implies, consider, certain rights, certain fundamental rights are available only to citizens, right? So if they are available to citizens and there is a law which abridges this particular right for a non-citizen, now can we use Article 13 in this case? No. We cannot use Article 13 in this case because Article 13 is protecting what is mentioned in fundamental rights. And if fundamental right is saying that this is available, this protection is available to citizens, why would Article 13 get activated for the protection of non-citizens? Right? I hope now you are able to have this clarity in mind. Right? Justice Matthew Bench. Special rights were given only to citizens, which render them protection against post-constitutional law. Parties to which fundamental rights are not guaranteed. For example, I said some rights available only to citizens, not to non-citizens. That piece of legislation will be valid. There you cannot activate Article 13, right? And that's why it will not be void for non-citizens because it is just talking about non-citizens, right? Now Article 13 subclause 3, it says meaning and definition of law. Because again and again we are saying law should not be inconsistent with fundamental right. But what is law here? And there's an interesting debate around it. What the debate? Law includes any ordinance, order, bylaw, regulation, notification. Now some of you might be thinking, why we are even talking about or the elaboration of this law? Because there are various definitions of law, and on which definition Article 13 can be applied. This was the question in mind of many people. And that is why Article 13 subclause 3 is clearly saying that even if a notification is released by state and this notification is against fundamental right, then Article 13 will be applied. If you are a district magistrate and you have issued an order and this order is against any fundamental right, then your order will be declared null and void. You cannot say, oh, the definition of law should be a law made by Parliament. No. At that point of time, court will say, please read Article 13 subclause 3. Right? Custom. Please remember this word custom. Customs which are prevalent are also under the definition of law. So if there's a custom which abridges fundamental right, then court can intervene and clearly say that fundamental rights are superior than this custom. Please remember it. You can expect one statement from here. Now, there are two exceptions to it. What are the exceptions? Number one, it means generally administrative and executive orders, those orders which are just having instructions or guidelines. It means these orders are not having some real power to create some action, to ensure some action. They are just instruction or guidance. For example, a notice board saying these are the general guidelines which you can follow. So in this case, this is an exception. Article 13 won't be applied here because direct change is not happening. Direct impact on someone's life is not happening in this case. Okay, please remember this is an exception. And UPSC's favorite genre are these exceptions. Now personal laws, they are also beyond the ambit of Article 13. Interesting. For example, Muslim personal law, right? So this will not be considered as law. There's a debate around it. We are going to discuss it in the issues part, but you should remember this is an exception. Now, whether a constituent amendment be covered under law, because we have said these are going to be covered under the definition of law. But what about constitutional amendment? If Parliament has made a constitutional amendment using Article 368, can we say that now this constitutional amendment will be put to judicial review? Using Article 13, now Supreme Court can declare this null and void. Many of you would say that is quite obvious. This has happened in many cases. Take the example of NJC even, National Judicial Appointment Commission. Parliament made this constitutional amendment and later Supreme Court said, ho gaya, null and void, because it is against basic structure and basic structure is independence of judiciary. We are going to talk about this issue later, but the point here is, the dimension here is whether constitutional amendment should be under law or not. So we have series of judgment development on this particular question. Now, why this question has been raised? Because this question is connected to supremacy of Parliament and judiciary. Because if it is considered as law, then judiciary will become supreme. Judiciary will say Article 13 gives me power to struck down any law which is inconsistent to fundamental right. But if it is given the status beyond the definition of law as mentioned in Article 13, then Parliament becomes supreme. Parliament will say, no, now you cannot use Article 13, you cannot declare null and void. My constitutional amendment is beyond this definition of law as mentioned in Article 13. So that's why this debate happened. Now let's talk about Shankari Prasad case. Quite simple. Just take a look how judiciary was behaving at that point of time. I'm talking about 1951. This is considered as some pacifist phase of Indian judiciary, because at that point of time Jawaharlal Nehru, the newly formed government, was having so much legitimacy in the eyes of people that judiciary was not in activist phase. They said includes only ordinary laws, not constitutional amendment. It means constitutional amendment are brought for amending even fundamental right, then judiciary cannot declare them null and void because Article 13 will not be applicable. Article 68 include the power to amendment of fundamental right, and that's how you saw first Constitutional Amendment Act to protect right to property. Laws Article 31 subclause 1, 31 subclause 2 were inserted, right? So that's how you can say first attempt to amend fundamental right happened, because judiciary said हमको लेना देना नहीं है, because already Article 68 Constitutional Amendment is beyond the definition of law as mentioned in Article 13. Now comes Golaknath case, and there we saw a change, a strong phase of judiciary. Judiciary revised earlier decision, and now judiciary said power of judicial review is supreme. Judicial review to hoga, and said under Article 68 can be challenged and review as law under Article 13. So it means here Constitutional Amendment Act was not law in definition of Article 13, right? But here Constitutional Amendment Act was given the status of law in Article 13, and if it is given the status of law in Article 13, it gives power to judiciary to intervene, right? Article 68 has limited amending power because now judiciary will use this Article 13. Parliament cannot amend fundamental rights. First strong stand. Any amendment violating fundamental right will be declared as void. This was done in Golaknath case. At this point of time, Parliament was on back foot now, right? So challenge 17th Constitutional Amendment Act. Power to amend fundamental right is limited, right? It is not unlimited. Now this led to tussle of power between Parliament and judiciary, and as a response, Parliament brought 24th Constitutional Amendment Act. Parliament said, judiciary, what's your role? Supreme Court said, I am ultimate interpreter of Indian Constitution. Parliament said, oh, you are interpreter, right? Can you amend the language of Constitution, any article? So judiciary said, no. When it comes to amendment, this power is given to Parliament. Now Parliament as a response said, yes, this is what I wanted to listen. Now see what we are doing. 24th Amendment. What they did? Parliament inserted Article 13 subclause 4. Parliament said, you are continuously saying that you are going to use Article 13. Now read Article 13 completely. Judiciary, you have subclause 4. Any amendment brought under Article 368 cannot be challenged under Article 13 in judiciary. Clearly mentioned. They said, read in Article 13 subclause 4, we have clearly mentioned that if we are using Article 68 to amend any part, then you cannot use judicial review. And what you are? Judicial interpreter. So now interpret what it says. Now your powers are limited. Now Parliament becomes supreme. Or you can say, in terms of judiciary, now Parliament stands to gain more power. Supreme word is wrong because India has constitutional supremacy, not supremacy of Parliament or judiciary. Now, Parliament changed the line under Article 68 from procedure of amendment to power of Parliament to amend. And this also is a symbol that power of amendment lies with Parliament. Also, Parliament added subclause 3 to Article 68, and which says nothing in Article 13 shall apply in Article 68. To make it ultra clear, Parliament made this amendment. Okay, if you miss reading this, also read this Article 68. It says that this Article 13 will not be applicable when it comes to power of amendment of Parliament. Right? I hope now you are clear about this journey. Now was the final, you can say, a judgment which changed India's constitutional history. This is Kesav Nand Bharti case versus State of Kerala. And in this case, now ball came into the, you can say, on the table of Supreme Court, and Supreme Court clearly said, who is the boss? We are the boss. And how we are the boss? Constitutional amendment does not come under our ambit of Article 13 law. Ordinary laws comes. So, Kesav Nand Bharti case saying, so Parliament, you are saying that you have amendment, you have power to amend any part of Constitution. Parliament said yes, this is exactly we have said, and you also saw this 24C Constitution Amendment Act. Kesanand Bharti case, Supreme Court says accepted. Yes, this is right. You have the power to amend Constitution, but you can amend any part of Constitution, but you cannot abridge basic structure of Indian Constitution because we are the guarantor. We are the guardian. Now, Parliament asks, what is this basic structure? We have now never read this phrase in Indian Constitution. Supreme Court said, this is judicial creativity. You should learn from us. Basic structure, we are going to define time to time. Because if we release a list that these are going to be part of basic structure, then you can actually find a way out. That we are going to decide on case-to-case basis. Any increase and decrease in power of legislature under Article 368 should not destroy basic structure of Constitution. The scope of amendment under Article 68 which Parliament holds was questioned. Power to amend the Constitution already implicit 24th. Now Constitution Amendment Act was not required because basic structure doctrine is in play. Right? Now Indira Gandhi versus Rajnarayan case. So it solidified the foundation which was already laid in Kesanand Bharti case. It said no limitation on amending power of Parliament. Happy. As people have elected them, right? That's why you have the power. But amendments of people will, it must be exercised. It means you have to exercise this power on the people's will, accept it, right? But it needs to be read with this basic structure, right? So inserted subclause 4, clause 5 in Article 368 to strengthen its power, but ended the amendability power tussle of judiciary versus Parliament, qualified certain features as basic structure. Because now these features will be applicable to put a restriction on what you cannot amend, despite clearly mentioning that this is the power of Parliament. Parliament is having power to amend any part, but basic structure cannot be flouted, right? So I hope this journey of fundamental right is clear to you. This PDF will be available in Shashank Tyagi for You Telegram channel. You can shoot me a message. If you find any difficulty, I'd be happy to help you out. See you in the next video.